Welcome to Legally Speaking. I'm your host, Sophia Haynes. Legally Speaking is a public service of You and the Law, a nonprofit whose mission is to provide information and resources to empower you in your legal affairs. While we provide legal information, it is in no way intended to be legal advice. So if you have an issue, make sure you retain the service of a licensed professional attorney. Today, we're continuing talking about business this month, and we're talking about the importance of trademarks. A lot of times you hear people saying, I trademarked this, I copyrighted that, I patented that, and we're going to talk today with an awesome attorney who can tell us exactly what that is. And her name is Ms. Barbara Ellenberg. Thank you, Barbara, for being with us today.
Well, thank you for having me. I'm pleased to be here.
Could you tell our audience a little bit about yourself?
Absolutely. First off, my name is Barbara Ellenberg. I'm an attorney with a very long name of a law firm, so let's just call it MP Law. And I have a passion for helping businesses grow. And one of the things that is just crucially important is protecting its intellectual property. So
it's a big word, intellectual property.
It sounds very important, doesn't it?
It does. So what are types of intellectual property?
Okay, intellectual property is typically not something you can touch. For example, a copyright, a patent, or a trademark.
Okay, so can you tell us what those three things are? What's the difference between them?
Absolutely, absolutely. You'll see the copyright symbol, which is the C with a circle around it, and that is a protection for an original work of authorship. And when you think copyright, you think books or photographs, original pieces of art.
Okay.
Okay? A patent protects a discovery or a process or an invention. Okay. And when you think patents, that's the P with the circle, you think of, for example, a specific machine that is designed to do nothing except drop equipment into another piece of equipment. Okay. Or into accounting software, very specific accounting software that will take your information from point A and get it to point B. Okay. Those are patents, or protectable by a patent. The third element, and what we're going to talk about today, are trademarks.
Okay.
And a federally registered trademark has the R with the circle around it. And with trademarks, let's think Nike swoosh or McDonald's the Golden Arches.
Oh, okay. So what? Okay. Oh, am I looking at what I'm talking about? You said a swoosh and the arches. So is it somebody a service or is it a product that I'm talking about with a trademark?
A trademark can protect a product or it can protect a service. And people sometimes get very confused about that. For example, if you were an accounting firm and you had a very unique tagline that went with your accounting firm, you could register that tagline if it's in association, if you're using it in association with your accounting services. By contrast, if you have t-shirts and your t-shirts are a particular type of t-shirts, they're the Sophia t-shirts, and we want to use a very...
That's a good idea, Sophia
Sophia t-shirts, I like that. You would use a trademark. But for purposes of a federal registration, there's no distinction between a service mark and a trademark.
Oh,
okay.
So they're the same on the federal.
Services.
So what about on the state side?
On the state side, it's a little complicated, but how you file what you identify as your goods or services is a little bit different. But ultimately, once you have either a state or a federal registration, you have a registration.
Oh, okay. So what does that trademark do for its owner?
That's one of my favorite questions, especially when I'm thinking about small businesses here. Now, we're not talking about Chrysler or GM here. I'm talking about a good, strong, regional company, maybe in 3 or 4 states. Let's just use a restaurant as an example. That restaurant may have a very unique logo, piece of artwork, or it may have a very unique name, or it may have a combination of a name and a logo. And that restaurant owner would want to protect that. And what the restaurant owner would do is file for a federal trademark.
So you say protect, that means keep anybody else from using it?
Correct,
okay.
Correct. And when you one of the biggest reasons for even smaller businesses to consider trademarking is ultimately your branding becomes very valuable. Remember, we were calling it intellectual property? Intellectual property can ultimately have a dollar figure, a very large dollar figure attached to it.
I guess the golden arches, I would think.
Exactly.
Yeah.
Imagine what it would cost if you wanted to purchase McDonald's and purchase its golden arches, its name, its branding. It becomes a very, very, very integral part of a business. And if you're growing up your business with the ultimate goal to sell it or to leave it as an inheritance to children, you want it to have as much value as possible. And protecting that intellectual property is one key piece of an asset.
So what would you say to an individual, say, I have a little small, what we know is a mom and pop something. Why would I even go through any of that?
There are multiple reasons. Like I said, one of them is because you want to build brand protection and build it as an asset for future sale.
Now let's go back a little bit.
Okay.
What is brand protection?
Okay, brand protection is, let's stick with the restaurant, McDonald's. If Sophia wanted to open a restaurant in Atlanta, Georgia, and you wanted to be McDonald's, guess what?
Couldn't do that probably.
You can't do it.
Yeah.
Because McDonald's protected themselves with their name and all of their federal registrations. Same thing, Starbucks coffee. If you wanted to open a coffee shop, you can't be Starbucks. You might be Sophia's, but
Can't be Starbucks.
but you can't be Starbucks. No, because they've got the ownership. There are different elements to ownership, and what actually, when you're using it, you obviously own it.
Okay.
However, the way to keep your ownership and to keep other people from taking it away from you or copying you is to register your mark.
So what if a whole lot of people already have that mark before I try to go out there?
Oh, that's a lot of fun. That seems to happen, unfortunately, too much. And that's yet another reason that even a small business would want to consider registering their trademark. Because in this world of the internet, people bump into each other all the time. It's very easy for someone in California to create Sophia's Coffee Shop and someone in Atlanta to create Sophia's Coffee Shop.
Okay.
And guess what happens when you both put websites up?
Everybody's confused.
Everybody's confused. Exactly. Now, if Sophia in Atlanta had called me up or someone else and said, gosh, you know, my restaurant is really taking off. I've got 3 or 4 locations. I've got one in Greenville, South Carolina. I'm getting big here. I'm starting to rock. Or your website presence is getting large. You would want to consider protecting your mark. And at the end of the day, if we filed and received a federal registration for your restaurant, for Sophia's restaurant, and a month after you've gotten your registration, somebody in California starts, and eventually you bump into them, you could write them a cease and desist letter.
And what is that?
A cease and desist letter, it's typically done by a lawyer, and it is a letter saying,
we have the rights.
Yes. Perhaps you're unaware. However, we have a federally registered trademark. We're going to ask you to change your name, and we're only going to give you 10 days to do it.
Oh, okay.
Or 20 days or whatever. And that triggers certain legal consequences if they don't.
Okay, so how would the public know that I had that mark?
Well, when we finish your Sophia's restaurant and you've got your mark, we're going to put an R with a circle behind your name up there in a superscript. You've seen it. One of my favorite examples is to take the Chick-fil-A bags. Chick-fil-A has got, I think last time I counted, 4 different registered marks on their bag.
Oh.
So,
and I never know. So now I'm looking at everything, looking for
exactly.
little R's and C's.
Yes, exactly. But you're telling the world you're registered. Now, that's not the trigger. The trigger is actually having your filing done at the United States Patent and Trademark Office.
Oh, okay.
So that's giving notice to the public. Your personal notice and all of your advertising and whatnot would be the R with the circle. So then you're giving them double notice, I guess.
Oh, okay. So that's, I guess, my next question. What if I didn't put anything out with the little circles?
I don't let my clients do that. I say, hey, guess what? We got a final registration. go get your things reprinted, send it to me. And that's one of the things that I do at the end of a successful trademark registration, is I work with the client to make sure that they integrate that R. Does it mean that you don't have a federal registration if you don't have the R with the circle? Absolutely not. Same thing with copyrights and patents. But why on earth would you go to all that trouble and not have it at the end of the day?
Exactly.
Yes.
So we hear about the federal you're talking about, we hear about state. What is the difference between the registrations?
Okay, the federal registration is the only registration that allows you to use the R with the circle. And the federal registration, the filing office is the United States Patent and Trademark Office. On the state levels, most states, and maybe all 50, I haven't checked a few like Alaska, but most states have the ability to receive a state registration. And if you are in Atlanta only, if you're within a state, you don't have an internet presence, you're not offering your goods or services across state lines, which is called interstate commerce, governed by the Commerce Clause, federal law. If you can't meet that level, you may choose to file at the state level. And in the state of Georgia, it is the Georgia Secretary of State who houses state trademarks and service marks. Even at the end of the day, if you have a state trademark or service mark, you cannot use an R with a circle. And that piece of paper, that registration, while it may give you rise to certain protections in Georgia, it's not going to do you any good in South Carolina.
Oh, okay. So I can try to do something to protect in Georgia only.
Exactly.
So what if I allow a lot of people to use my mark, and even though I register it, and I highly recommend. Remember, we were talking about your trademark being a piece of property. It's intellectual property. Just like you're not going to freely allow someone to use your home without having a lease. We kind of want to write a lease for that trademark. If you're going to let somebody use it, it's called a license, a licensing agreement. And that's important, and people do that all the time. You're not going to know it as the public, but among the person who holds the federal, and we're just going to assume we're talking about a federal trademark here, but the person who owns the federal trademark has the right to license it to other people. Now, when you say license, that means let other people use it.
Let other people use it. You're giving specific permission. If you have Sophia's restaurant, and I say, gosh, your restaurant is so wonderful, could I run a Sophia's restaurant? I'll have the same menu, and I don't want to talk about franchise law here, but that's really what happens.
It's akin
with
to a franchise.
Yes.
Okay.
Yes, that's what happens with franchises. You and I might enter into a deal where I'm going to set up my Sophia's restaurant, and you're going to give me a license or permission to use the name. And guess what? With that license agreement, you have the right to say, hey, Barbara, you have to behave a certain way. Your restaurant has to be clean. You've got to be, you have a right to put conditions.
So protecting my brand.
Yeah, exactly. Exactly. And at the end of the day, if I'm not living up to my end of the bargain, if we write that licensing agreement properly, you can take it away from me.
Wow, great information. You gave us a lot.
I know, this I hadn't even thought about the licensing aspect when we were talking, but that's a very important part of owning something.
Well, we're going to take a break here because we're about halfway in. Can you believe that? The show's going by so fast. Anyway, when we come back, we're going to talk about, how we go through this thing and how much it costs and all of that.
Okay.
So we'll be back in just a few moments with Attorney Barbara Ellenberg. You are tuned into Legally Speaking, a public service of You and the Law. You and the Law is a nonprofit whose mission is to provide legal information and legal resources to empower you in your legal affairs. If you would like to have a question answered or a topic featured on Legally Speaking, feel free to contact us online at www.youandthelawtoday.org. You can also sign up there on our website for our mailing list, as well as follow us on Facebook and Twitter. Remember, with every right comes responsibilities, so know your rights and accept your responsibility. Welcome back. We're talking trademarks with Attorney Barbara Ellenberg. Before we left, Barbara, we talked about the difference between trademarks, copyrights, and patents, and basically what they all do. So let's just say I got my idea and I'm ready to go full throttle with this thing. How much would it cost for me to be able to put this federal protection in place?
That is a wonderful question, and that's usually, if not the first, the second question that I'm asked when people are trying to protect their property, their intellectual property. The actual application, the check that I have to write to the Patent and Trademark Office when I file an application on someone's behalf is either $275 or $325, depending on the type of application it is, and that is just the filing fee per application per class, and that alone can confuse people, because remember we were talking about restaurant services for you. Let's say that you are very similar to Starbucks, even though you're Sophia, and Sophia's restaurant, you've got this wonderful composite mark, which means you've got a beautiful drawing as well as the words Sophia's restaurant.
Okay.
And in addition to offering restaurant services, you actually allow people to take cakes home. Okay? When you and I talk, and we talk about how we're going to register, we're going to have a discussion about registering in more than one class. So we may register your trademark for restaurant services, but we may also register it for cakes. Which is the goods.
So it's not a one-shot, one-all.
It is not. No, there's not an easy answer to this, unfortunately. And this is where people get tripped up. And while I think LegalZoom can be a wonderful tool, I want you to know it is one of my best referral sources when things have gone sideways, and I get a telephone call from someone who thought they had protection in a certain way, but gosh, they didn't really talk to a lawyer. They just filled some stuff out online.
So they fill stuff out.
Exactly. So when you and I were talking about Sophia's restaurant, I would be the one to be asking you, well, tell me about your business. Let me understand. So I educate myself so that I can then come to you and say, well, Sophia, you're selling cakes too. Maybe the boxes that the cakes are in, we don't want anybody to steal the name for the cakes, because what if you become Sarah Lee? You're Sophia Lee.
Yeah, exactly.
And you end up in the frozen pie section and the frozen cake section in the grocery stores. We want to protect your brand for your cakes as well as your restaurant.
So am I protecting the name or the way I use the name?
Yes.
Both.
Yes. When you get that final R with the circle, that final registration, you've got to use your trademark exactly the way we filed it.
Okay.
So if you change, we have to make a new filing. And I spent some time last night in preparing for our talk today. I went into the Patent and Trademark Office website and I did a little bit of research on Starbucks.
Okay.
Because Starbucks has had so many different logos over the years.
And they do change up quite a bit.
Yes, they do.
Yeah.
There's a page and a half of Starbucks. And I started calling them up, and it was funny because we had the restaurant services. We had coffee. We had tea. We had coffee grinders. All of those are in different classifications. And every time they created a new logo, there were new sets of filings.
Wow.
So not that you have to be married to your filing forever, your artwork, but that is one of the questions I ask my clients. Do you like your mark? Do you feel like you want to use it for a while? Do you feel vested in it? And those are the kinds of things when you're filling out a box online, you're not going to think about that. So that's one of the intangibles that actually talking to an attorney will help as you go through this process of deciding whether to spend the money. But I never finished answering your question about dollar figures. The filing fee alone, like I said, is either $275 or $325 per class per mark.
Okay.
On top of that, you're going to pay me for my expertise in all of these conversations that we have. You're also going to pay me, and I'm using the word we or me very liberally. You know what I mean? An attorney. Thank you. That attorney is going to guide you through the entire process. And there are a lot of ins and outs that just based on years of experience, we understand how to answer questions in the trademark office that you might not even realize there's a legal significance to. For example, the owner. Are you going to hold this mark individually, or are you going to let your corporation own it?
And what's the difference?
There can be a difference, and ultimately we can change who the owner of the mark is, but that's just one thing that you and I would have to talk about, because you may want to hold it individually and have a stream of income for licensing the mark. So Sophia would own the trademark and license it to her corporation. Then when you bring other shareholders into your corporation, they don't own the mark.
Oh.
You see? So
yeah,
even
and
who the
as
owner
an individual would not have thought of that.
Exactly. So that's just one of a myriad of questions. That's why how we answer something as basic as who's going to own the mark matters, and yet another reason to be in front of an attorney when you're going through this process. But by the time we go from our first conversation to the R with the circle, if we get it, which we hope we will, the typical cost is usually around $2,500.
Okay.
And that cost is typically spread out over the course of a year or so, because
we're going through all the processes to get it done.
Yes, it is a lengthy process.
Can you give us briefly, I file it, and then is there something else, some other steps?
There's lots of, yes. And not to get too technical, but there are different types of filings. There's an in-use filing and an intent to use. And again, a decision that we'll have to make at the filing level. And if we have an intent to use, there are other pieces we'll have to drop in later before we can ever get to a final filing. If we are already using the mark in interstate commerce and we're ready to roll, the shortest time I've ever gone from filing an application to receiving a federally registered trademark was 11 months. The longest time was 7 years.
Oh, wow.
Well, there was a lawsuit in the middle of the 7 years.
Okay, well, that will stop it.
That will slow you down.
Now, you keep saying interstate commerce, but everything's on the World Wide Web now. So is it considered interstate commerce if I'm on the web, but I only provide services in one state? Or how does that work? As with all laws, there's not an easy answer, but generally speaking, yes, generally speaking, interstate commerce is very broadly defined. So a single location in Atlanta that has a web presence where you are inviting people from other states to come to your place usually is sufficient for purposes of interstate commerce. And I should probably have a federal mark as opposed to a state mark, or does it matter?
Ultimately, a federal mark will trump a state mark. And don't forget that state mark is geographically binding. So if you have a Georgia mark and I come along later and create Sophia's Restaurant in South Carolina and I file a federal mark, I'm going to get the other 49 states. You may be able to continue, if you were ahead of me in time, you may be able to continue in Georgia, but I get the other 49 states. And what happens is ultimately I become the steamroller and you become the ant. And you could ultimately, just because of the sheer dollar powers that I might have, if my Sophia's Restaurant exploded in these other 49 states, I might make it so difficult for you that you don't want to continue.
Wow, so there's a lot to think about.
There's a whole lot to think about. Yes, there is. And again, we don't have all the answers. I don't have a crystal ball. Most of the time, I'm glad I don't. But every once in a while, it would be nice. But for a very nominal investment, somewhere between $2,000 and $3,000, to get that federal registration can be huge. And another thing is, and this is another intangible, having that R with a circle, it really gives you some level of credibility. You're out there in the community. You've got a federally registered mark. You have stood behind your business. You're not pumping coffee out of your basement. You're a substantial business, and you really can't put a price tag on things like that, but it matters.
Well, if you're gonna go in business, go in business.
Exactly.
Now, let's say I went through this process and I have my mark. How long does that mark last? I mean, how often do I need to do this process over and over again?
In theory, your federal registration can last indefinitely. However, the Patent and Trademark Office requires filings.
Okay.
Unfortunately, the first filing is between the 5th and 6th year after registration.
Okay.
Most folks have not kept in touch with their attorneys.
Okay.
And they really don't think about it. I have one on my desk right now where a fella had a federally registered mark, forgot about it. It expired. When he realized it expired, which just was a fluke that he even found out because they're not going to send you reminders, he went to refile and is having trouble refiling.
Wow. Has somebody taken it in the meantime, or is just
it's been
paperwork?
It's been a problem on several different levels. But again, those are the types of things. When I send the federal registration out to a client, that's one of the things I say. There are filings between the 5th and 6th year. I let you know. I hit you in the head with it. Most folks just flat out never read that fine print on the back of their registration.
Wow.
And then after that, there are filings at the 10-year anniversaries. Which again, if you're not Procter & Gamble or Coca-Cola or Chick-fil-A, you don't have a battery of attorneys taking care of you. And if you did it yourself, really, what are the chances you're going to remember about this at the 5-year mark?
Yeah,
or the 10-year?
That's part of those processes and procedures, and having good people on your staff if you're going to do business.
Absolutely, absolutely.
Okay, so what if I want some more information? Are there any resources out there that I can get information to find out more about trademarks or
the United States Patent and Trademark Office has a wonderful website. Their FAQs, their frequently asked questions,
and we will add that to our website.
They are so good, and at every turn they caution you to seek counsel. You can do it yourself, just like you can go to court yourself.
Or you can operate on yourself, huh?
Exactly. Probably
not
not
wise.
No. But you can do it yourself. But again, I hope I've given enough information so that you understand the complexities, even in very simple sounding questions. Okay. It makes sense to seek wise counsel.
Well, I'm convinced, Barbara. How can I find you? If I want to talk to you, how can I find you?
You can find me. My email is barbara@mplaw-llc.com. My telephone number, which anybody is welcome to call. It's okay. It's 404-232-9209. And again, I'm Barbara Ellenberg. I'm an attorney in Atlanta, Georgia, and I love helping small businesses grow.
All right. And what is that website for the Patents and Trademark Office?
USPTO.gov.
USPTO.gov, folks.
Yes.
And we'll also have that on our website again at youandthelawtoday.org. As we wrap up, Barbara, is there any area on trademarks that we didn't touch on that you think would be important for the audience to know?
I think if I had to have one takeaway, when in doubt, register. When in doubt, register, because it's going to be better for you now than coming into my office when you've gotten the cease and desist from someone else. Because we're already moving towards a lawsuit, and you're going to add another zero to that legal bill.
So it couldn't hurt. It could only help.
Exactly.
Great. Well, thank you so much, Barbara, for being here with us. You have provided some invaluable information I know our audience will totally benefit from. And they'll probably blow your phone up, too.
That's okay.
Oh, there you have it, folks. We talked about trademarks today and the importance of trademarking your ideas. If you took the time to start a business, put a concept in place, doesn't it make sense to protect it? Remember, Legally Speaking happens every Sunday at 6. And until next time, remember, with every right comes responsibilities. So know your rights and accept your responsibilities. We'll see you next week.